This matter to come before the court this morning is State of Ohio versus Samantha Lockhart. I understand the state has waived. Counsel, you have 15 minutes to present oral argument. We have read the briefs and we are ready to see more.
Thank you. May it please the court, Donald Gallup on behalf of defendant appellant Samantha Lockhart. I want to initially point out a clerical error in the brief. With assignment of error 3, if you look at the statement of the assignment of error that's in the table of contents, the statements of assignment of error, it's plain error argument for the lack of a jury instruction for a lesser included offense. If you actually look at the page that the assignment of error starts on, it has a double jeopardy argument. I think that was a cut and paste of another thing. I would ask the court to disregard the double jeopardy argument. It should be a plain error for the lack of a lesser included jury instruction. Thank you.
That is my first question.
Thank you
for answering it for me.
I knocked one out, so that we don't have to deal with that matter. However, I will address that assignment of error. Obviously, there was no lesser included mentioned, and you look at the way that the testimony came out, it certainly looks like it was more of a criminal mischief case, and that might have been what the jury should have been looking at. Wasn't requested, so the jury didn't have an opportunity to do it. I would suggest that could be considered plain error. Moving to assignments of error 1 and 2, assignment of error 1 is also a plain error because it looks like there was a criminal rule 29 motion made, but I'm not sure if it was timely. I cited some other case law where some districts have said, well, even if you don't renew it, the issue's still preserved. I don't know how this court interprets that line of case law. What do you do when a criminal rule 29 motion is made that far into the case? Perhaps if this court considers it preserved. If not, I would ask to look at it under a plain error review. Because assignment of error 1 and 2, for vandalism, and I cite this case out of the 2nd District, State versus Levingston, where someone breaks a window. They break a window of a government building, I believe in Mechanicsburg Police Department, something like that. And the court finds, well, that isn't substantial physical harm to government property. And the vandalism is overturned with a broken window. The case before the court right now, the facts before this court, Mr. Mickle testifies that nothing was damaged. Things were messed up, things were soiled, things were dirty, things had to be cleaned, things had to be vacuumed. But what about this computer that was covered in glitter and silly string? Well, we cleaned it off and dusted off and it worked fine. Okay, what about the floor? Well, we vacuumed the floor and the vacuum's fine. The only things that might have actually suffered permanent damage is I believe there was some personal property of Ms. Clapper, and it said like my sweater was ruined or picture frame was ruined. Well, that's not something that's being used in the course of business. It's not government property in furtherance of a public office. Is that criminal damaging? Well, yeah, probably is, but the jury found her not guilty of that. There's not much we can do. So under the facts of the case, even if this court doesn't agree with the 2nd District's holding in Levingston and says, look, if you break a window in this district, we're going to uphold your conviction for vandalism. Nothing was permanently damaged in this case. It was, please, Your Honor. Well, it's just, I mean, certainly you could say, well, you just can't go into an office and spread this kind of disarray and mess and everything, and there should be some punishment for that. But it looks like that fits the statute of criminal mischief.
Wasn't the element that was being determined in Levingston serious physical harm? And isn't the one here under which your client was under physical harm? Does that make any difference to your argument? Because
it's a B1 versus a B2. I thought it was the same. I thought it was 290905 B1 in both cases, but if it's a different subsection, I apologize. I thought it was both B1.
I'm just reading in your brief.
Yes.
And the appellee concurs. In Levingston, the 2nd District found that a conviction for vandalism was against the manifest weight of the evidence because evidence did not show serious physical harm to property.
Yes.
If I'm correct, and please feel free to correct me, the standard for in the indictment for your client was physical harm to property.
Your Honor, if that's true, then I certainly apologize. What I didn't do in the Levingston case is I didn't cite the actual clause that that charge was under. And so if it is a different clause under the vandalism statute, then certainly that would be distinguishable. But even if that is the case, the testimony from Summit County employee is there's no harm. I mean, there was no harm. He's like, look, I had to clean it. It took me a couple days to clean the computers and vacuum. The custodial staff had to, clean the desks and vacuum the rugs and things of that nature. And certainly you say, well, that's criminal conduct, okay, but it's not vandalism. And that's why we get into, really this is a criminal mischief case, but there was no lesser included requested, which I think is plain error. And I think the Criminal Rule 29 motion should have been granted on vandalism, but this court might say it wasn't timely made, so I'm using that under a plain error as well.
Is there a requirement that the physical harm be permanent?
Well, Your Honor, that's an interesting question. I mean, I think that if you look at, the two statutes to really look at is criminal damaging versus criminal mischief. And obviously, you could say, well, under the facts, she's guilty of criminal damaging, but the jury said she wasn't. In criminal mischief, it seems to be it's not permanent. If it's criminal damaging, there's something that is permanent. A broken window,
The chair, you can't sit in?
a chair. The chair, I didn't see, was there testimony that the chair was damaged to the point they had to take it out and repair it, or I don't think there was.
I think there was, the chair had so much powder in it, you couldn't sit in a chair without powder.
Oh, no, certainly no question, no question about it. So you have to go in and you have to get, but I mean, in a criminal mischief case, a lot of it is spray painting. I have a can of spray paint, I'm gonna spray the desk. Well, that's awful, but guess what? You can take turpentine, clean the desk off. I mean, well, we don't, you can certainly say that's a burden, and that's causing public resources to be used to have to clean this desk. It is, but that's what the statute of criminal mischief is. It's something that can be, I guess it's a question of, does it need to be cleaned or does it need to be repaired? And what is the difference between cleaning something and repairing something? And Mr. Mickle testified, so the computers, I'd pull the hard drives out and throw them away, or I had to take the hard drives out and solder them back together or something like that. Without, you say that's a repair, and that means that the hard drive was damaged or something. But he said the computer was covered in glitter and silly string, and I cleaned it off, and I did routine maintenance on it. I was going to do anyway. Computer works fine. The chair is covered in powder. We vacuumed it off, wiped it off. Now the chair works fine. There was nothing physically altered in the chair. It was covered by garbage, so to speak, covered in silly string, covered in glitter and confetti and things of this nature. Those didn't actually, to get on a more metaphysical level, it didn't change the physical property of any of these items. The chair was still a chair when this act happened. Nothing was bent, nothing was broken, nothing was fractured or anything like that. It was just a mess that needed to be cleaned off. And again, the court could say, I think there might even be an argument, like the second district, that this court could modify the conviction on its own. I think the court in the second district did that under some sort of criminal rule 7 or something or other. And it's a little unusual for an appellate court to do something like that. But I could certainly see a court saying, we're not going to remand this for a new trial, we're just going to modify it right here. It's a criminal mischief case, and that's probably what the jury should have looked at had that question properly been put before them. If there's any other questions, I would certainly entertain them, but if not, I would ask the court to consider the 3 assignments of error as proffered.
Thank you.
Thank you.
Thank you.
Court will take the matter under advisement and issue a written decision, which will be mailed to both sides, as well as posted on the Ohio Supreme Court website, which can be accessed through the 9th District Court of